Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book from Edward Elgar Publishing. This book I thought was very interesting because it's very relevant to practitioners. It's called the Court Mediation Reform book with a subtitle, Efficiency, Confidence and Perceptions of Justice. And we're looking specifically at the way in which we mediate and what would need to be done to modernise the system. It's been written by Shahia F Ali, and as I say, it comes to us from Elgar. Elizabeth and I looked at the book and had a chat. She was the lead writer on the book, and she gave this book the title for our review, Global Research from 10 Different Jurisdictions on the Mediation of Civil Claims. And I actually do quite a lot of work. I'm not a formal mediator, but I do a lot of work in this area, so I was very interested to see what they were coming up with by way of observations, if I can put it that way. And you've got a nice picture of the justice, the scales of justice there. There's the front, there's the side, and then there's the back. A lot of detail. You can see the noise that is made there by it's a hardback. It runs to 290 pages. The index at the back is by page numbering. It's quite a detailed index actually that you've got here. You can see the index starting there. Then you've got a bibliography, a lot of detail, as is to be expected with any of these publications. Very high class publications from Elgar. There's the selected bibliography. We don't review many books anymore from them, but I was delighted to be able to review this one. There's the front page. Then there's a quote there which you might like to just have a look at. I'll read it out. It says, "When perfect justice reigns in every country of the Eastern and Western world, then will the earth become a place of beauty. The dignity and equality and the ideal of the solidarity of the human race will be realised." And that was made in a Paris Talks in 2012 by Adr Mechanism. Now, that's just to give you some idea of the approach. There's the detail, and by the way, this is available as both an e-book and a normal book. There's the contents section there. There are a total of 4 parts, 14 chapters. Then you've got figures and tables. Quite a lot of detail going in. There's an overview there of the book itself. Judicial Systems Advance, involving concepts of justice are reflected, because obviously things change over the years. A lot of acknowledgements after that. And then another further overview with the various headings. And you can see a lot of footnoting. You can see also paragraph numbering used throughout in many of the cases. I did find the footnoting very detailed, which is very helpful, but you've got a lot of body copy as well in the actual book as you run all the way through it. And of course, civil procedure of the UK courts is nicely covered towards the middle of the book, an objective of the CPR, for instance. So you've got a lot of directly relevant information for the practitioner here. So what do we actually say about the book? Well, we say this: does mediation work for general civil claims? While the arguments for and against will be endless, this new study by Shahia F Ali of the University of Hong Kong provides some interesting research-based insights which will certainly contribute to the debate, or just possibly fan the flames of further controversy, in which case this new book from Elgar should provide a handy and useful reference. And that's our starting off point, because the final decision is a political one, but at least we as the practitioners can have some fairly substantial input. And of course the practitioner, the actual clients themselves will generally be quite reticent about it, but they will also have a comment to make from time to time themselves. The challenge, says the author, of course, is obtaining sound empirical data on diverse ADR mechanisms, ADR being alternative dispute resolution. Basically, it's dispute resolution outside the court. That's the word alternative, but everything we do is dispute resolution. So some of these words are not quite what you think they are. Now, of course, the mechanisms here, the ADR mechanism, the challenge is widely acknowledged in academic circles to be a bit of a problem because you do need the data, and getting the data is actually what is part of this work. Whether that's going to affect any decisions, I don't know, because the bottom line on all of this is about money, and it's about state money as well. But we'll get on to that in a minute, perhaps. The author's research has therefore been extensive as well as intensive and rigorous, and the result in the form of this book is consequently regarded by many as a unique analysis which draws on case studies from 10 global mediation jurisdictions. That means 10 different legal systems from the US, Australia and Hong Kong to India and France. So you've got a wide range of approaches, all of which effectively is trying to see if there's another way round, basically having a big round court. And that, in blunt terms, that's part of it. But the difficulty, as we found with the CPR in the UK, is the problem of how it starts off as being relatively straightforward and it just begins to get bigger and bigger and bigger and more complicated. And that's, I think, a substantial valid criticism, which of course is one of the reasons with mediation why if we can get away from the court-based stuff, that in many ways, because it's not an imposition from the court at the end of the day, it's a mediation where the parties will agree, it will try to give a little bit of solid support to a reasoned outcome for the clients, because they're the ones who get pretty fed up when the decision goes against them. But that's really the detail for the practitioner. Now, an important distinction in the book is made between voluntary and mandatory mediation programs. An important one. The UK, Hong Kong, France, Holland and Malaysia favour the former, voluntary, and of course federal courts in the US, Australia implement mandatory. Courts in Italy, China and India also take the mandatory route. I'm of two minds about that at the end of the day, because of someone somewhere's got to impose a decision if you can't get the parties, the warring factions, to settle their differences. So it's an argument that works both ways, putting it in its bluntest form. Now, the differences between mandatory and voluntary models are carefully examined, together with the variations which inevitably arise between one jurisdiction and another. And as Professor Ali further explains, the book highlights positive lessons learned from selected jurisdictions, analyses of local circumstances, and it distills best practices. Such snags and pitfalls are as enforceability, always a problem, very important, and instances of refusal to mediate are also discussed. And I fall with the clients very much into the latter category, where they won't mediate, and also where enforceability becomes the big problem once you've got your orders, because that's just the beginning. And for many people, they don't understand. They think it's the end when you've got the order, and it isn't. And so you can see that the mediation concept does have rather sort of interesting approach in certain cases. And bearing in mind its convincing arguments, balanced viewpoints, and the veritable tsunami of research it contains, note the extensive bibliography, because that, I think, is extremely helpful. There are a lot of different sources there. This book will doubtless attract the interest of lawyers as well as mediators, and I'm glad, because I can see there was a big attempt about 10 years ago, even at the English bar, to get many more people to do mediation. I have to say, unfortunately, the reality is that the people I deal with don't want to mediate, and if we don't get a settlement by actual negotiation in court, it's imposed, and it's as simple as that. I can't make it any simpler. But we do try our very best to try to avoid a full conflict in court if we can, because no one really wins. It may be entertaining for some people, but not the people who are under cross-examination. Not at all. Now, bearing in mind its convincing arguments then that have been said, what the author says here is that the relative advantages and challenges of mediation in a given jurisdiction vary according to the functioning of the underlying national civil litigation. Of course, it is that structure. Generally, therefore, and of course I'm only taking the UK or the England and Wales perspective, but generally, as the relevant inquiries have revealed, the healthier the economy of a nation, the more efficient are its courts and judicial systems. Regardless of jurisdiction, however, the overall aim is to achieve just outcomes in the resolution of disputes. And to this end, of course, more research and more objective analysis are needed. In the meantime, I think it's worth considering the commentary of Judge Dorothy Nelson of the US Court of Appeals in the Ninth Circuit, who refers to Ali's book as offering the most comprehensive qualitative study and insights on global court mediation I have encountered. It should be in the hands of every court in the world. I think that's a really nice recommendation, and I think she's probably right. That in fact, I wish more people would look at it. Sadly, we live in a real world where people really are going for each other sometimes. It doesn't work quite like that. But I thought this book was very helpful from the point of view of the practitioner. And it's fair to add, of course, that this new Elgar title indeed reveals itself as a distinguished addition to the growing corpus of literature on global mediation. And of course, that's going to continue. Remember, the book was cited as being published in 2018. I've recorded this in the summer. Let's have another look at it. I was very pleased with it as a book. There's the front and then there's the spine. There is some very interesting commentary which I've referred to. I mean, Judge Nelson's point is mentioned, of course, up there. But there is a lot of stuff. Opening it in the middle, it's not a big book. Mediation in the Australian Federal Courts. So what you do is you do have a nice background, and I think from the point of view of anybody who's very interested in mediation, this area of law and practice is a very, very important one. You can see the structure. You've got sort of subheadings and paragraph numbering and footnotes and everything else. But generally speaking, I think Professor Ali is to be congratulated for producing this excellent book. And I'm very grateful to Elgar for sending it to us for review. I think it opens up another possible avenue for the future of where we might be going with mediation in the next 25 to 30 years. Who can say? But with the costs involved of court hearings, you can see, and the stress on people, you can see the need for other forms. Thank you to everybody concerned anyway. It was a delight to read this book. Thank you. Bye-bye.